Hello, everyone. Thank you very much for joining us today. This is a webinar on medical inquiries, the ADA, and disability disclosure. I'm very pleased to announce we have Tracy DeFreitas, who is the lead consultant and ADA specialist for the Job Accommodation Network, or JAN as they're commonly known. She's joining us today to discuss what employers are allowed to ask, what medical information they can get from you, and sort of all your rights around disability disclosure and sort of disclosing your disability throughout the hiring process. Before we get started, I'll just run through some very quick logistics. So audio is available over the phone line. Unfortunately, it's not available through your computer speakers, so you will have to dial in. You can also access our live captioning service, which has a link to. You can just click on in the chat box, which is to the right of your screen. We'll also be recording this presentation and uploading it onto our YouTube channel next week. We'll also email all registrants a copy of the presentation and a link to the recorded webinar next week as well. So if you need to drop out during it, don't worry, you'll be able to see the whole thing once we send it out to you. During the presentation, everyone will be set to mute. Please use the chat box to the right of your screen again if you have any questions during the presentation, and Tracy and I will answer them at the end. If you're not able to access the chat box, you can also email me your questions at gnagle@gettinghired.com. That's GNAGLE@gettinghired.com. You can also download the PowerPoint. That should be available to download as well. Lastly, we'd really like to know your thoughts about the webinar, so please feel free to email us any feedback you have on what we could improve, on what you found useful, or any information you'd like to see another webinar on and know more about. If there's any other topics you think would be useful for you in your job search, please do let us know. And back to today's webinar. So Tracy DeFreitas, as I said, is the lead consultant for the Job Accommodation Network. With more than 20 years of experience in the disability employment field, Tracy supports all JAN specialty teams as lead consultant and Americans with Disabilities Act ADA specialist. She provides expert disability-related federal employment law and workplace accommodation consultation regarding a broad range of medical impairments and ADA issues. So thank you very much for joining us today, Tracy. And just quickly before we get started, I just want to say a thank you to our two employer sponsors for the webinar today. Campbell Soup Company is a global food company headquartered in Camden, New Jersey, and they have an annual sale of $8 billion. They look for individuals who enjoy working in a fast-paced, team-oriented environment, who like to be challenged, and who value the opportunity to make a difference. Walgreens is one of the largest drugstore chains in the U.S., with more than 8,000 stores in all 50 states, the District of Columbia, Puerto Rico, and the U.S. Virgin Islands. It's been recognized multiple times for its disability inclusion initiatives in the workplace, which you can also read about on their career site. Walgreens is now actually working towards its new goal to fill more than 20% of its workforce with people with disabilities. So you can find all of the jobs for both Campbell's and Walgreens on gettinghired.com. And now, without further ado, I will introduce our presenter today. And Tracy, you can kick it off whenever you're ready. Tracy, I think you need to press *6.
Can you hear me now?
Yes.
Okay. All right, great. Thank you, Gabby. I appreciate it. So welcome to everyone joining us today. Today's presentation is about medical inquiries and the Americans with Disabilities Act. And as you know, the federal ADA is a law that does prohibit discrimination in employment and in some other areas against qualified individuals with disabilities and requires employers to make reasonable accommodations. Today our focus is going to be on the restrictions the ADA places on employers' ability to ask medical questions and require examinations during the various stages of the employment process. And I'm also going to cover some disability disclosure related issues as well at the end of the presentation. So we have a lot to cover today. I'm not sure I'm going to make it through everything, so we may skip around just a little bit. But let's just go ahead and jump in and get started then. All right, so why limit medical inquiries in employment? Well, in the past, employers frequently requested information about an applicant's physical or mental condition during the pre-employment stage. This is prior to the ADA. So, for example, employment applications would require medical information, and interviewers would ask disability-related questions as a normal practice. Employers would then use this information to exclude applicants with disabilities before their ability to perform the job was ever really fairly evaluated. But now, due to the enactment of the ADA, employers are required to evaluate an applicant's qualifications without regard to their medical condition. So there should be a non-biased consideration of the individual's non-medical qualifications for a job. The limitations on inquiries and exams apply during each stage of the employment process, and the rules are a little bit different depending on what stage you're in. So during pre-employment, post-offer, and then when an individual has become employed or has been working for, whether it be a month, 2 months, 6 years, 10 years, whatever it might be, so during that employment stage. I sometimes compare the inquiry restrictions during the various stages to the warnings of a traffic light. So you have the pre-employment stage, that's the red light stage, where questions about disability and medical impairment generally can't be asked before an offer of employment is made. Now sometimes there can be exceptions like going right on red, but there are limited circumstances that allow for this, and we'll talk a little bit about that. The pre-employment post-offer stage is the green light stage. After an offer of employment is made, an employer may ask questions about disability or require medical exams, and neither have to be specifically job-related. There are some rules around that, and we'll get to that as well. And then finally, once an individual is hired, employers are once again restricted in asking disability-related questions. Disability-related questions and medical exams have to be what's considered job-related and consistent with business necessity. And there are limited circumstances that allow for that when you become an employee. So as we move forward, I'm going to break all of this down and provide some more details so that you understand when it's acceptable to ask questions if you're an employer or to be asked questions if you're an individual. So let's get started with the pre-employment stage here. So under the ADA, the pre-offer stage is the most restrictive. So this is pre-employment, pre-offer. Employers aren't supposed to ask disability-related questions or require medical exams during this stage. Under the ADA, a disability-related question is one that is likely to elicit information about a disability or a medical condition, or a question that's sort of closely related to a disability in some way. For example, any question that will lead to information about a medical condition, legal medications someone might be taking, injuries the person has sustained at some point in their life, or a person's workers' compensation history. Those are just some examples. Questions that are not likely to elicit information or that may have various possible answers to a question, and only some of those would contain disability-related information, those would not be considered disability-related. So let's consider a few examples of those kinds of questions. So for example, why are you using a cane? Well, this question may lead to information about a medical condition and a possible disability. How many days were you sick at your last job? Well, at the pre-offer stage, an employer may not ask about how many days an applicant was sick because this question relates directly to the severity of an individual's impairment. And so therefore, it's likely to elicit information about disability. However, an employer may ask if an applicant can meet the employer's attendance policy. Another example, have you ever filed a workers' compensation claim? Well, this is obviously not acceptable because it's going to relate directly to whether or not someone had a previous injury that could be a disability. One more, what medications are you taking? Questions about medications will almost always lead to information about a medical condition and are inappropriate during this stage. So keep this in mind, that medical inquiries are not permitted on employment applications, during job interviews, or during background and reference checks. And also, employers can't ask third parties questions that can't be asked of an individual directly. So an employer can't ask a former employer if an individual has a disability or required accommodations during their previous employment. Those are just some things to keep in mind. Now, what about asking if a reasonable accommodation will be needed for a candidate to participate in the hiring process? Can an employer ask if an accommodation will be needed, or maybe tell applicants how to
stupid laptop.
or tell applicants how to request accommodation for the hiring? Just a reminder, if you're listening on the call, if you would please mute your line. Thank you. So, in fact, it is possible for employers to ask if accommodations are needed for the actual hiring process. So we're talking about accommodations that might be needed for interviewing, that might be needed for test taking, pre-employment test taking, or filling out an application, for example. So they're able to actually ask that question. It's only related to the hiring process. It's not related to accommodations to perform job duties, but it's a way for them to ensure that if an accommodation is needed, an individual has the ability to request it and knows how to go about doing that. So let's review just a couple of other acceptable inquiries during pre-employment. An applicant may be asked about his or her ability to perform job functions, including whether or not they can perform functions with or without accommodation. This is because an employer is entitled to know if the applicant can perform the functions of the job. And what they can't ask you to do is, can you perform the job duty with an accommodation or without an accommodation? They can ask the question as long as it's all together and the answer is simply yes or no, not with an accommodation or without an accommodation, then it is permissible. Of course, during this stage, they may ask about non-medical qualifications and skills, education, experience, and so forth. All applicants can be asked to describe or demonstrate how they would perform tasks as well. An employer may ask applicants to do this, but the key is that all applicants entering into the same job category must be asked to do this as well. So there should not be sort of a random selection of who they're going to ask to do this. It's a situation where it's something you have to do consistently with all those who would be entering into that job category. There's a minor exception to that, and I'll talk about that in a minute. So it's important to understand what can and can't be asked. I did mention earlier that it is possible to ask about the ability to meet attendance requirements. During the pre-offer, it is sometimes a case where an employer might ask about drinking habits as well. And the key here is that an employer could ask whether or not an individual drinks alcohol, but they can't start asking probing questions about how frequently an individual drinks or how much an individual drinks, because it could eventually elicit information related to alcoholism, which could fall under ADA. What about current and prior illegal drug use? Well, this depends on the nature of the question. So questions about current illegal drug use are acceptable because current illegal drug use is not covered under the ADA. However, probing questions related to past illegal drug use, for example, have you ever been in rehabilitation for illegal drug use, or that kind of question could be related to past addiction. And so any questions that could refer to a history there could reveal information about disability and are not permissible. Okay, so just to be clear on what can't be asked before an offer of employment is made. This is the very beginning stages of applying for a job, interviewing, and you haven't been offered employment yet. Again, no questions about disability unless accommodation is requested for hiring and the disability is not known or obvious. So when it's a situation where someone does state that they need an accommodation for the hiring process, an employer may ask about the disability and the need for accommodation for hiring, but they should sort of limit their scope of questions and kind of stay a little bit more focused on the accommodation piece of that. But the fact is they can ask for some information in order to establish that the individual qualifies for accommodation. No questions about lawful drug use. So you just heard me talk a little bit about illegal drug use, but now we're on lawful drug use. So this is different from illegal drug use. An exception to this rule may be if let's say someone took an illegal drug test and the results need to be validated in some way. Let's say they're not using illegal drugs, but somehow a false positive came up. That may be a situation where you would give the individual an opportunity to sort of validate that they're taking a medication that is legal and give that applicant the opportunity to disclose that legal drug use after a positive result in order to validate that finding. In general, an applicant may not be asked questions about ability to perform major life activities like standing, lifting, walking, unless these functions are specifically related to the abilities, the applicant's ability to perform the essential duties of the job. So if standing and lifting and sitting for prolonged periods of time and things like that are necessary, then the employer can address that as long as it's part of the job. And again, questions about workers' comp history, we've already covered that. I also mentioned earlier that employers can't talk to other sources of information and ask questions they couldn't ask an individual directly. So here's a more specific question. Before an offer of employment has been made, can an employer ask an applicant if accommodations will be needed to perform job functions? This is a little different than the question I asked earlier about the hiring process. Now we've moved forward a little bit and we're looking at the future and whether accommodations would be needed. Well, the answer is sometimes, but again, it's similar to what was described on the previous slide. The employer has to have a reasonable belief that accommodation will be needed to perform job functions before there can be any discussion about the future need for accommodation. So there has to be some sort of reasonable belief there that the individual might have difficulty. A reasonable belief may exist because of an obvious disability that seems as though it might affect performance of job functions. It could be because of a hidden disability that the applicant has voluntarily disclosed during the pre-offer stage, or because the applicant has voluntarily disclosed the need for accommodation. Sometimes one or more of these criteria may be met and an employer might be in a position to address whether or not reasonable accommodation is needed to perform job duties. When this happens, I typically suggest that the focus be on accommodation, not be on the medical impairment so much, so that we are just kind of trying to figure out, can something be done that would enable that person to perform the job duties if it's obvious that the person would have difficulty. So I try to kind of steer employers away from getting into too much information from the medical side of things. One of the questions Dan sometimes receives is if an employer may ask a particular applicant to describe or demonstrate how that person would perform job tasks if other applicants aren't asked to do this. So remember, I said earlier that as long as an employer is asking all individuals in the same job category to describe or demonstrate how they would perform the task, that's okay. But what about a situation where the employer doesn't customarily do that? Can they ask a particular applicant based on some knowledge that they might have? There can be situations when an employer may take this step, but only when there is a reasonable belief that the applicant won't be able to perform the job duties because of a known disability. So again, you're kind of back to what's known in the situation. A known disability is one that's either obvious or voluntarily disclosed by the applicant in some way. This doesn't mean that just because the employer is aware of a disability that they can ask the individual to demonstrate or describe how they'd perform the job functions. If there's not a reason to believe that the applicant would be unable to perform the job functions, then the threshold hasn't been met to require this of the applicant. So again, it comes back to what do we know and what sort of impact do we know that the disability will have on performing job duties. Now we're going to move ahead to the post-offer stage. The post-offer stage of employment, this is where the employer has made a bona fide offer to the candidate to accept a position. We're still in pre-employment, but the candidate has accepted a position to begin working for the employer. So you're just sort of a step beyond the pre-employment stage. During the post-offer stage, after an offer of employment has been made, Employers may ask disability-related questions and perform medical examinations or require medical examinations. Also, the job offer may be conditioned on the results of a post-offer disability-related question or medical examination as well. So it's very common for employers to require post-offer testing, examinations, and inquiries. Sometimes we have employers who have a full list of a questionnaire that needs to be completed, and it asks for all sorts of information that really just doesn't seem to make sense. But they have the ability to do it, and so this may happen during post-offer. So let's discuss the medical inquiry details of this stage of employment then. The post-offer stage is really the least restricted stage in the employment process. It's what I call the green light stage, basically. And according to the Equal Employment Opportunity Commission, the EEOC, which is the federal agency that enforces the ADA, disability-related questions and medical exams do not have to be job-related during post-offer. During post-offer, employers may ask about workers' comp history, prior sick leave usage, illnesses, diseases, impairments, and just general physical and mental health-related information. But there are some rules. So while any disability-related question can be asked, the employer must ask the same questions or require the same exams of all employees entering into the same job category. So you kind of see a trend here. You know, it's about if you're going to ask these questions and do these sorts of things, then you don't want to sort of single just people with disabilities out. If an employer asks post-offer disability-related questions or requires post-offer medical exams, it needs to make sure that all employees entering into the same job category are subjected to the same examination, the same inquiry, regardless of disability. Also, all information obtained at this stage, it becomes a confidential medical record, and the employer has to adhere to the confidentiality requirements of the ADA, which are rather stringent. An employer may condition the job offer on the results of the medical inquiry or exam, as I mentioned earlier, and it is possible for them to request additional medical information based on the findings from an initial evaluation as well. So it just kind of depends on what happens in that stage as to you know, what they might feel as though they need to ask about. So if a post-offer applicant is excluded from employment based on information obtained during post-offer, the reason has to be what's known as job-related and consistent with business necessity. So what I'm saying is if for some reason they find out information during post-offer and they're not pleased with it, or they're a little bit afraid the individual can't do the job, well, they have to decide whether or not the person could perform the job duties safely. They need to decide if that information that they have would prevent the individual from performing the job, and do a factual assessment of that. What it means to be job-related and consistent with business necessity is that the reason that they choose not to offer employment has to be based on a legitimate measure of qualification for the specific job, not a general class of jobs. It has to be that particular job. That person can certainly be held accountable for meeting the qualification standards for the position, and the standards and measures must be related to the essential functions of the job, not the marginal functions. Meeting the job-related and consistent with business necessity standard also means that it's necessary to determine if the qualification standard or selection criterion can be met with accommodation. So it's necessary to actually look at accommodations when there is some concern regarding those limitations and the impact on job performance. So for example, if it's found that an individual has a lifting restriction for a position that does require some lifting, is there an alternative way to move whatever must be moved that will enable the individual to complete the task, such as a compact lifting device, or perhaps breaking up the weight and creating smaller loads, or having somebody else provide assistance. So it's basically a matter of having to take a look at, is there an alternative way that's going to enable this individual to perform the essential duties? So the employer can't exclude the individual solely on the basis that the individual has a lifting restriction. They do have to take a look at those accommodation possibilities. Okay, so as I said, you know, you basically have to always remember, you revert back to accommodation and figure out, is there a way? Now, I'd like to take a minute to talk a little bit about medical examinations in the ADA, because employers often require exams during post-offer. A medical exam is a procedure or test that seeks information about someone's physical or mental impairments or health. As I've shared, medical exams are not permitted during the pre-offer stage, but can be required during post-offer. Again, for all those entering into the same job category, employers can't simply pick and choose who must undergo an exam, basically. So what are some of the indicators that an exam is medical? Well, if the examination is administered by or interpreted by a healthcare professional of some kind, if it's invasive, like let's say like a blood draw, for example, that'd be considered a medical examination. If it measures physiological responses, so for example, such as heart rate or blood pressure, or if it's designed to reveal an impairment or physical or mental health-related issues. So there are a lot of factors to take into consideration to determine if something is indeed, or an exam is indeed medical in some way. Some examinations that are not considered medical would include a psychological examination, unless it is medical. So for example, a test that measures personality traits is not medical, but a test designed to diagnose mental health impairments is medical. So it just kind of depends on what we're testing there. Vision tests, unless they're medical. So for example, a test that measures ability to read labels to perform job functions is not medical, but a test that diagnoses vision impairment is medical. Tests to determine illegal use of controlled substances don't fall into the restricted medical exams category because use of illegal substances is not protected, and employers have the right to test for illegal drug use. Physical agility tests that measure ability to perform tasks are not medical, but if you start evaluating physiological responses to a physical agility test, then it becomes medical. Examples of exams that are medical include tests for alcohol use, physical examinations, and blood tests. So lots of stuff to consider there when assessing whether something is considered an examination. I'm going to skip this next slide and move real quickly to look at the post-offer stage. So we're moving ahead here. We've looked at the pre-offer stage. We've looked at the post-offer stage. And these, I would say, that pre-offer is the most restrictive employment process, the red light stage, then the least restrictive stage, that post-offer green light stage. And now we're headed into the employment stage, which is again a stage when medical inquiries and examinations are restricted unless they're job-related and consistent with business necessity. So let's revisit that idea again. Medical exams and inquiries of employees have to be job-related and consistent with business necessity, and this applies to all employees, not just those with disabilities. EEOC states that a disability-related inquiry or medical exam of an employee must be job-related and consistent with business necessity when an employer has a reasonable belief based on objective evidence that one, an employee's ability to perform essential job functions will be impaired by a medical condition, or two, an employee will pose a direct threat due to a medical condition. So those are the kinds of things that you're going to be paying attention to in determining, whether or not there is a reasonable belief that an individual would have difficulty performing job duties or may pose a threat in some way. And when that happens, you've met the threshold to ask job-related questions. Disability-related inquiries and medical exams that follow up on a request for reasonable accommodation when the disability or need for accommodation aren't known or obvious, those are typically job-related and consistent with business necessity because the employer has a right to determine, does this person have an impairment? How does that impairment affect ability to perform job duties? Is this something that's going to fall under the ADA? And this is one of the more common reasons why employers make medical inquiries of employees. Other situations that maybe, where an employer might be able to request information from employees include periodic medical examinations and other monitoring under specific circumstances, like for employees in positions of public safety. This kind of situation may be job-related and consistent with business necessity. An employer's reasonable belief that an employee's ability to perform essential job functions will be impaired by a medical condition or might pose a direct threat, that might be a situation that is indeed job-related and consistent with business necessity as well. So, of course, that has to be based on objective evidence that's obtained or reasonably available to the employer before making the disability-related inquiry. So you really want to think it through before you're taking that step to ask those disability-related questions of employees. Sometimes employers will have to initiate the medical inquiry process of employees when an individual with a disability is exhibiting performance or conduct issues. Sometimes that job-related standard will be met then because an employer might know about a particular employee's medical condition or maybe has observed some performance issues and can reasonably attribute the problems to the medical condition, but maybe the individual hasn't requested accommodation. So that is a situation that could meet that threshold. Just to give you an example, maybe an employee with a known disability like MS, for example, and they may be having difficulty meeting the required production standards. The employee hasn't requested accommodation, but the employer's observed the performance issue, and they may have a good reason to believe that the limitations associated with MS could be contributing to the performance problem. So in this type of situation, the employer could address the performance problem as they would with any other employee who's not meeting performance standards, and we encourage employers to make sure they're doing that. And then extend assistance to the employee by asking if there's anything that can be done to support the individual in meeting the required standards. And that oftentimes opens the door to discuss accommodations and then address any medical issues that might be relevant. So the employer would be within their right to ask medical questions and ask the employee to provide information, if this type of situation arises and it becomes obvious that the performance issues are related to the medical impairment. Dan does offer several resources related to this topic of performance and conduct issues and when to ask and when not to ask. And so we have these linked here, and you can access those directly through the hyperlinks. So now let's take a look at, here's just a quick example. Katie has been experiencing side effects from medication. She's taking medication she's taking for a chronic medical condition. The side effects make it difficult for her to arrive at work on time, and as a result, she requested a schedule modification as an accommodation. Is this the kind of situation where an employer could ask disability-related questions or require a medical examination? I would say yes, because when an accommodation has been requested and the disability isn't known or obvious, an employer may request limited medical documentation in order to determine whether an individual is a person with a disability and whether or not the accommodation is needed. And the employer does not need to know about Katie's situation to determine if she has a disability. They basically need to understand, what exactly is going on and what sort of impact does the medical condition have on this person's ability to arrive to work on time. The employer might need to know how her medication is affecting her, how it affects her ability to arrive at work, how long she might be affected by the medication, so things like that. So it may be possible to make some modifications, but the employer could ask for some additional information in order to proceed in that process. When an accommodation has been requested, an employer may ask for reasonable medical documentation about an individual's disability and limitations because the employer is entitled to know that the individual has a medical impairment and needs the accommodation. This is the case when somebody has a condition that perhaps is not obvious. So in more situations, it's going to be when there's a hidden disability of some kind and the employer can't really reasonably tell that the person has a disability. Only sufficient information or limited information can be expected, not complete medical records. The documentation should be sufficient, and it should sort of describe what the individual's impairment is, what their limitations are, the severity, the duration of the impairment, what activities the impairment limits, and then ultimately why the accommodation is needed. And it just, how much information is needed will depend on the situation. It's not the case that we always necessarily have just a quick blanket statement of those things that will absolutely be needed. So it's really, you want to look at it case by case. One of the questions we're often asked is, can medical information be required from a medical doctor, or the documentation be required from a medical doctor? Under the ADA, it states, or EEOC states, that an employer can require the information to come from an appropriate healthcare or rehabilitation professional. That can include doctors, it can include physician assistants, nurse practitioners, psychiatrists, psychologists, nurses. It can also include vocational rehabilitation specialists who might be familiar with the individual's impairment and limitations and their need for accommodation, licensed mental health professionals, chiropractors. So the appropriate individual will depend on the situation and what sort of information is necessary. All right. I'm going to skip this next slide here, and let's talk a little bit about disclosure. So all of this medical inquiry business really relates right back to disability disclosure. So for many people, there's this trepidation over revealing disability-related information. So one of the most difficult questions to answer is when or whether to disclose medical impairment and request accommodation. And deciding if and when and how to share disability-related information with a prospective or current employer can really be quite overwhelming. It's a very personal decision. Generally, there's no obligation to disclose disability-related information to an employer until the need for reasonable accommodation becomes apparent. So what that means is if you have a hidden disability and that disability is not going to affect your ability to perform job duties in any way, or your performance, there isn't affected in some way, then there's probably no reason to reveal the information. But it is a personal decision, so you have to decide for yourself. Disability disclosure can occur at any time during or any stage of the employment process, including pre-employment, post-offer, and while employed. Again, up to the individual to decide when to share the information. Why disclose? Well, usually when an accommodation is needed, it's to receive benefits or privileges of employment, or sometimes it's to explain an unusual circumstance. So, for example, when there's a performance issue, or an individual is behaving in an unusual manner, the need to disclose or request accommodation will kind of become evident when that person knows there is a workplace barrier related to a disability. So you've really just got to feel out the situation and figure out when the time is right, if ever, because if it's not relevant to the employment situation, it may not be necessary to share the information. Some tips to keep in mind, the timing of a request can be rather important. It's not necessary to disclose a disability if sharing the information has no impact, as I mentioned. On the other side of that, it is better to disclose a disability and request accommodation before job performance or conduct problems occur. So job performance suffers or conduct problems occur. So you want to sort of head off a situation where it may be possible to implement accommodations that would help someone meet the performance requirements of the job. So don't wait till it's too late. Employers can impose their performance and conduct requirements on individuals with disabilities as they would anyone else. So the sooner the better. Don't wait till you have a significant performance issue. So let's address some disclosure issues during the various stages of employment. Here's a question. Are applicants required to disclose their medical impairment at a particular time? The answer is no, but with limited exceptions. So generally, employers may not require applicants to disclose information about a disability prior to an offer of employment. An exception to this rule, and I mentioned this a bit earlier, is if you're going to request accommodation to complete an online application or participate in a job interview or take an employment test, that's a situation where you are going to have to disclose that disability if you're going to request accommodation. And the employer can ask for information about your disability. When disclosure occurs during the hiring process, usually because accommodation is needed for that process, of course, the employer can talk to the applicant about your disability. This should be done in a timely way in order not to affect the hiring process. The candidate should be willing and able to explain how the accommodation will enable them to participate in the hiring process. And I mentioned earlier it may be possible that reasonable documentation might be requested in order to support that. So what does that mean? So in the application stage, if you're needing accommodation for the hiring process, the reasonable documentation can be requested if the need for accommodation is not known or obvious. This might be simply a note from the individual's healthcare provider or rehabilitation professional that sort of explains what the person's limitations are and what their need for accommodation is. So I typically encourage employers not to delve for too much medical information, but to just get a basis for what the impairment is and why the accommodation is needed. Now, I mentioned employers can't require individuals to disclose disability-related information, but they can invite or request individuals to do so. So in limited circumstances, employers can ask applicants to voluntarily disclose their disability status without violating the ADA. They just have to make it very clear that it is voluntary. This is often used for affirmative action purposes. So when there's a mandate or the employer has their own program related to affirmative action, then they invite individuals to disclose disability. This also comes in accordance with federal laws like the Section 503 of the Rehabilitation Act, which applies to federal government contractors. They are actually mandated to ask individuals to voluntarily disclose disability-related information. And they, in fact, have the Section 503 Voluntary Self-Identification of Disability Form, and I'd imagine many of you have come across this. It can be a little bit confusing, but what needs to be clear here is that it is a voluntary form. It is up to your discretion to decide whether or not to complete the form. It is a form that all federal contractors are required to use, so you shouldn't see too much variation in the form. I think just the key here is to remember that it's something that an employer can't require you to complete, but it's a form that can be used at various stages of the employment process. This could be with applicants, where they're asking an applicant to disclose. It also actually is required to be used at some other stages in the employment process once an individual's been on the job. I bring it up here because I think that sometimes it causes some confusion and people aren't really sure whether it's something they have to complete. Here you can see I've excerpted information directly from the form to share with you to basically explain that the form isn't very intrusive. The self-identification form states that disabilities include but are not limited to, and I won't read all of these, but just to give you some examples, autism, blindness, cerebral palsy, major depression, HIV, AIDS, MS. So these are just, cancer. These are just some examples that are included on the form, but it's not a comprehensive list. It just is there to help people kind of figure out, okay, yeah, maybe I should complete this form based on what I know of my disability. So there's at least some information here to help you understand or figure out whether or not you want to complete the form. It goes on to ask the individual simply to check one of the boxes as shown here that states that either the individual has or had a disability, or previously had a disability, or does not have a disability, or you don't wish to answer at all. So remember, it's voluntary. You can complete it or not. It doesn't ask for detailed information about your disability. You're simply saying yes or no, or I don't wish to answer. So it's just something to be aware of, and that you may come across it, and I wouldn't be too worried about it. Some people get concerned about the disclosure, but I would say it's not something to be too worried about. Okay, so now talking about the post-offer stage here, if an employer asks disability-related questions during the post-offer stage, is the individual required to disclose his or her disability? Here's a little bit of a tricky spot. The decision whether to share information about a medical impairment, it's of course up to the individual to decide this. However, an employer may condition the offer of employment on the satisfactory completion of the medical questionnaire or the examination. So if it's not completed or an individual refuses to participate in an exam, an employer may rescind a job offer. Individuals are often compelled to share disability-related information during the post-offer stage because a lot of employers will ask for medical information during that stage. And employers aren't limited in the categories of questions that they could ask during that stage. And so that means that after receiving the conditional job offer, it could be asked just about anything, whether it's your entire medical history. So as long as, and again, this is as long as the employer asks the same questions of others entering into the same job category, of course. So while this essentially requires an individual to disclose information about disability even when an accommodation is not needed, the information revealed during the post-offer stage can't be used to rescind the job offer unless it can be shown that that person would be unable to perform the essential duties of the job, and again, with or without accommodation, or that they would pose a direct threat in some way. So it's up to you to decide how much information to share at that point. I do encourage individuals to be truthful. You don't necessarily have to share lots of details about your medical impairment, but if you're asked direct questions, you want to make sure that you're being honest about answering those questions. All right, employees and disclosure. So once an individual is employed, is disclosure necessary when accommodation is requested to perform job duties or to receive a benefit or privilege? Well, under the ADA, employers are only required to provide accommodations for employees who are experiencing workplace problems because of a disability. So therefore, unless you let your employer know that you have a disability, then the employer is not going to be obligated to consider accommodations under the ADA. Under the ADA, in response to an accommodation request, the employer can ask questions such as what is the impairment, what are the limitations, what medication is needed, what impact is the impairment having on job performance, and so those questions can be asked at that point. The individual can be asked to provide medical documentation, and we've covered that a little bit earlier. So basically, it's a case of if you're going to request accommodation, then what you're saying is, I have a disability, and so the employer will be privy to information about that disability. Here's another question that is a little bit tricky. Another common question is an individual with a disability required to disclose his or her specific diagnosis when requesting accommodation under the ADA? Many employees who request accommodations prefer not to disclose their diagnosis, usually out of fear related to stereotypes or stigma attached to the condition. There's no formal guidance from the EEOC regarding this question. Under the ADA, employers may be able to insist on knowing the name of the impairment as part of determining whether the employee has a covered disability. However, keep in mind there are some state laws, for example in California, that do restrict employers from requesting a diagnosis or asking for detailed medical information. And so it's important employers should be informed about the requirements of their state law before they're requesting detailed medical information from their employees for ADA purposes, because that state law is going to supersede the ADA because it's more protective for the individual. An employee may begin by giving a more general description of the condition when an accommodation is requested. So, for example, I have a mental health impairment, or I have a condition that affects my immune system. So in some situations, a limited description will be enough to satisfy the requirements of providing information. Sometimes it won't sufficiently describe the individual's impairment and limitations, but it just kind of depends. So again, employers can request the documentation to determine whether the disability exists, and they may be able to request a diagnosis. So you just need to be prepared for that. If you're not comfortable, start out a little bit more general, and then we'll see how it goes from there and what the employer feels as though they need in order to proceed in the interactive process and provide accommodation. I'm going to finish up my talk here with just offering some resources available. Understanding the rules around medical inquiries and exams in the ADA can really be quite tricky. I really just covered a broad range of issues around this topic. There are a lot of details that some of this might be a little bit complex, and there are also, of course, a lot of issues that could be addressed, but we have limited time today. The following resources may be helpful if you'd like more detailed information regarding this topic. You're free to go ahead right into these links here, but we have some information related to disability disclosure and employment. We have a practical guide to requesting and negotiating reasonable accommodation. There's also an employer's version of that document. Job applicants in the ADA, and then EEOC also offers couple of documents that are very helpful: pre-employment disability-related questions and medical exams in the ADA, and disability-related inquiries and medical exams of employees under the ADA. So they essentially address the rules around medical inquiries based on the stage of employment. So I hope that this information has been helpful to you. It's a lot of information all at one time, but I think it was a fairly good overview of some of the things to consider. Of course, if you ever have any questions, you can contact Jan directly. Our number is 800-526-7234 voice, 877-781-9403 TTY. Of course, on our homepage, you can access all of our contact information at askjan.org. You can also use our chat feature to speak with a consultant as well. So at this time, I'll go ahead then and be happy to answer any questions that people have. Gabby?
Thank you, Tracy. That was really interesting. A lot of really useful information there. If you're able to just make me the presenter again, yep, that's fine. Then, yep, we'll start looking at some of the questions. We have quite a few here. The first one, somebody said that they've made it a practice to disclose that they have a disability, which is that they're legally blind. But they say, but I think disclosure is hurting me more than helping me. Would not disclosing my disability actually help my chances of at least getting an interview? So, you know, quite a common concern we hear from job seekers is, you know, will being honest and upfront about disclosing their disability lessen their chances of getting an interview. Do you have any thoughts around that?
Yeah, I mean, certainly we hear that a lot, and I think that people feel compelled to, or they think they're having to be honest about something in doing that. But, you know, I think if you're qualified for the job that you are applying for, and you think that you can perform the essential duties of that position regardless of your disability, then I don't necessarily know that there's a reason to specifically disclose that information right away. Ultimately, you know, once they have assessed your qualifications for the position and decided whether or not you're the best candidate for it, then there can be discussion about that. But I don't know that it's absolutely necessary. I guess what I'm saying is it's not a matter of being honest or dishonest. It's a fact of whether or not it's relevant to them determining if you're qualified for the position. So if you feel as though you could perform the essential duties and you know that that's with or without an accommodation, I don't know that you necessarily have to feel compelled to disclose that information right away.
Right. So we have another question, actually, that touches on what you've just said. May an employer ask at the interview stage, can you do the job with or without an accommodation?
Yes. And so let me go over that again real quickly because it's confusing. And it's kind of hard to describe it without showing somebody what I mean. But they can ask the question, and it's just one question, okay? So they can ask, can you perform the essential duties of the position with or without accommodation? One question. And your answer to that will be yes or no. You don't necessarily have to say anything more than that. If you know that you have a disability and you need accommodation, but you know that accommodation will enable you to perform the job duties, then your answer to that question is simply yes. What an employer cannot do is separate. So for example, if you were filling out an application and it said, can you perform the essential duties of the job with, check here, or without, check here, accommodation. So the idea here is that they're not supposed to be able to extrapolate from that whether it is with or without accommodation. And I hope that makes sense. It's sort of a strange concept, but the overall gist of that is they can ask whether you can perform the essential duties of the position.
Right. Good. So I hope that clarifies that. There's somebody else who has, I think it's just worth clarifying about employers being able to ask about alcohol and drug use. Somebody is saying they understand employers require a drug screen, but it's surprising to hear that an employer can ask if you drink.
They can ask if you drink alcohol, yes, because that is not going to elicit information about disability.
Right. Okay. And so they can ask that kind of question, I guess, pre-employment at any point?
Correct.
Right. Okay.
Because it is not a disability-related question. Now, if they get into detail about that, you know, how frequently do you drink, how much do you drink, then that could lead to information that could end up exposing information about alcoholism, possibly.
Right.
So you have to kind of stay away from those probing questions.
Sure. Something kind of similar. Can an employer ask in an interview about criminal history which could elicit past history of DUIs or drug charges if having a clean driving history or criminal history is not a requirement of the job.
Okay, so that is technically not an ADA issue because asking about criminal history is not disability related. To my knowledge, an employer is permitted to ask about that, but that would be covered under other statutes. So, and the reason that, I mean, if it's criminal behavior, it's not something that comes in under ADA in some way. So, to my knowledge, yes, an employer could ask those questions.
Okay.
And just because something reveals information related to DUI doesn't necessarily mean you're receiving disability-related information. I mean, someone could receive a DUI just simply because they made a bad choice, not because they were using some sort of substance. So.
Yeah. Okay. I am supposed to make an amount of money less than a certain amount to continue getting SSDI. Should I disclose the amount so that they can be aware of my scheduling hours per month? Also, I have a bad memory, but I've been on the job for 2 months and the employer is happy with my work. It would be helpful if my work hours were consistent rather than being different each week. So I think this is sort of, you know, I guess disclosing this kind of information would indirectly give them information about, you know, the person having a disability.
Okay, so I kind of see this as a two-part question. So I'm going to address it in 2 ways. So the first part there related to the SSDI and the hourly situation. You need to keep in mind that somebody who may be receiving SSDI and knows that they need to limit their hours is something that you can choose to share that with the employer or not. You know, one approach to that is simply letting them know that you have limitations regarding your hours. You don't necessarily have to explain why. The employer doesn't have an obligation to accommodate that. So if you're asking for limited hours because of the fact that you're receiving SSDI, that's not going to come in under ADA because you're not limited based on your medical impairment from working, but rather the SSDI requirements are limiting you. Now, the other piece to that is if you are having some memory issues or are having some difficulty with the consistency of work and would find that having a more consistent schedule would be better for you because of your medical impairment, then yes, that's a situation where you would go to the employer and explain what's going on and ask if it's possible to modify your schedule as a form of accommodation when you know, the medical impairment is affecting you. So even though your performance might be good, but you know you're having some memory issues or just simply having a consistent schedule would be better for you because of your medical condition, then that's when you would discuss accommodation.
Right, okay. A couple of others here. Hopefully we can squeeze them in before we finish. Are there other situations beyond federal contractors or affirmative action where employers can ask if applicants have a disability?
No. I mean, they can, you know, again, those are only voluntary situations. So, you know, when affirmative action comes into play or under Section 503, it's only voluntary. So they can ask, but they have to make it very clear that it's voluntary and the individual has no obligation to disclose. But pre-offer, there really aren't any other reasons that would allow an employer to ask those questions except for those that we discussed.
Sure. Okay. If someone needs to drive for their job and they come to work with a cast on their arm, is it okay to ask the employee to have their doctor fill out a form to let the employer know their restrictions?
It could be, yes, because in that situation it may be job-related and consistent with business necessity because the individual may need to use that hand or arm in order to perform the job duty. So now the employer can't just automatically exclude them from performing it, but they do have the right to figure out, is this person still capable of performing the job duty, which could include asking them to get a letter from their doctor or their health care provider that explains that they can perform the duties of the job.
Okay, and this is something I know you covered earlier. Can an employer ask about accommodations during the interview process if they see a visible disability, for example, a wheelchair, without, excuse me, without the applicant disclosing?
And again, that comes back to it depends. So if, just because someone has a disability, that doesn't give the employer the ability to ask them about it. Now, on the other hand, if the employer has what we call a good reason to believe that the individual would have difficulty performing the job duties because of that known disability or that obvious disability, then they can address accommodations. But there are going to be limited circumstances when that's the case. So not just simply based on having a disability can an employer ask questions. There has to be a reasonable belief that the person would not be able to or would have difficulty performing the job duties.
Great. Okay. Well, there's a couple other questions, but I am going to send those to you offline,
Okay.
Tracy, just because they sound, a little bit more complicated than what we're looking for right now.
Right.
Well, thank you so much for your time. It's been really, really useful. And if you didn't catch Tracy before, she did a previous webinar on requesting accommodations, and you can access the recorded version of that with captioning on the Getting Hired YouTube channel. So feel free to look at that if you want more information about accommodations. And of course, as Tracy said, you can contact Jan directly on their website or email. They also have a live chat. And ask them any more information you'd like about, your particular situation. So thank you all very much for attending. I hope it's been useful, and keep a lookout for the email we'll be sending to you next week, which will have the URL to the recorded webinar and also the presentation included in it as well. So
Gabby, thank you for the opportunity to present to this group today.
Oh, thank you. Thanks very much, Tracy. And everyone enjoy the rest of your week.